Okay.
Thank
All
you.
right. Second case is Charlie Limpty Eddie. Mr. Eddie in the courtroom. All right. Mr. Eddie, who is your attorney? Ms. Rockwell. Ms. Rockwell is there. She is.
Well, Judge, I really haven't been retained, but is a Madam,
Just one second. Ms. Rockwell, just one second. Mr. Eddie,
Yes, ma'am.
you might want to come up to this table because it appears your attorney is not your attorney.
Judge, is the prosecutor in the courtroom?
Yes, Ms. Marshall Story is at the table. Ms. Marshall, could you do a testing, 1, 2, 3, Ms. Story, so that we can make sure it's heard?
Testing. Oh, yeah. This is okay.
So much better than. Okay. All right. Mr. Eddie is at the podium. Do you see him? He's got a green sweatshirt. All right. And, okay. All right. Ms. Rockwell, you may proceed.
Good morning. Well, good afternoon, Judge. I just wanted to make sure Miss Marshall's Story was in the courtroom before I addressed the court. I have been speaking with Miss Marshall's Story regarding this matter and also with Mr. Eddie, which is his last name, Charlie Eddie. I expressed my concerns to Miss Marshall's Story that I would be getting on so late and didn't know if it was going to cause some disruption because the case was set down for trial today. I have been in discussion with Mr. Eddie regarding a possible resolution of the case, possible disposition of the case, and have not been able to really speak with Miss Marshall's Story since I've been communicating with him. I don't know if the best, and I don't want to hold up any kind of progress, but I don't know if the best way to address this would be for me to call her directly or, but as I stated this morning, Judge, I was concerned about putting an entry in on a matter that was so close to trial.
Yeah. This case has been pending since the accusation was filed in May of 2020. Like you said, there's no entry of appearance. We've had a couple of court appearances. The case was reset twice, and now it's been reset based upon the defendant's request for a trial. So, Ms. Marshall Story, are you prepared to go forward with trial today?
Yes, Your Honor. The victim and the sergeant that was the arresting officer are both here in court. And my apologies to the court reporter, Erica, ERIKA, Marshall, MARSHALL -Story, STORY for the state.
All right. So, Ms. And just for the court reporter's benefit, this is case number 20 CR 0034358F. It's position 1 on our calendar. So it's position 1 getting ready for trial. So, Mr. Eddie, it appears that your attorney is not your attorney because she's not filed an entry of appearance. And this case is set for trial. Are we ready to proceed?
I don't know if I have a choice. I was looking or hoping to give time.
This case was set for trial.
Prepared to
This case was
research.
set for trial today. We have the prosecutors present. We have the alleged victim present. We have the police officer present. We have you present. We don't have an attorney for you. She's on screen right there, and she's saying she doesn't know whether she is going to be a representative because she came in late in the game.
Yes.
So my question is, we are all ready because you wanted a trial.
Well, the reason she's so late here is because the late notice of me getting it, and the reasons they were reset the previous time were all on y'all's account because you all weren't prepared, they didn't have it, what have you. And I'm just asking for a reset so that my attorney can be
Denied.
prepared. I understand.
Okay, I appreciate your understanding. Ms. Rockwell, I'm not resetting the case, as I've already said.
I understand.
Everything else is ready. What would you like to do?
I understand, Judge. I do think that, I have explained the offer to Mr. Eddie. I would rather him allocate to the court whether or not he would like to accept the offer. The offer, from the state, because he has no record, was, the typical, DV, offer, technically, Judge, for him to complete a family violence intervention program. The case does have a little age on it, like you said. It is from May of 2020. My understanding that is that there has not been any, problems between the parties since then. They are co-parenting. They are not living together. I have not spoken with the victim, but my understanding is that she does not want him, to do any jail time.
All right.
Um, and
So,
she,
so let me get the offer from the state and let's see what we're talking about, okay?
Your Honor, the state's recommendation in this matter is 12 months to serve 3 days. The defendant has served those 3 days with credit for time served. And the domestic violence intervention program. And Your Honor, we would ask that probation not terminate and that he have no further violent contact because there is a child involved with the victim.
And the name? I'm sorry, I know I wrote it down earlier, but I don't have that note. What is the alleged victim's name?
Miss Marshetta,
Mhm.
Marshetta Brown. And Miss Brown, if you would just briefly stand so the judge can see is present here.
She's behind the pillar. There she is. Okay, if you have a seat right there, Ms. Brown, thank you. All right, Mr. Eddie, you do have a right to a trial. The case has been reset for a trial. I don't know why it's taken this long for you to speak to Ms. Rockwell. That's entirely something with you. But I'm going to go to trial today. In the meantime, Ms. Marshall Story, prosecutor, has indicated that they're willing to offer you a sentence of 12 months, no jail time. You'll be required to do a domestic violence intervention program. Those are 6-month-long classes involving domestic violence awareness and so forth. And you'll be on probation while you're taking those classes. And that probation will be for 12 months long. I will waive your probation fees for the first 6 months while you attend and complete these classes. And then after that, you'll just be on reporting probation. For the entire time, you shall have no further violent contact with Ms. Brown. Is this something that you would like to consider?
And when are these 6 months classes or what?
Repeat?
These 6 months classes, are they daily, weekly, what is?
They are weekly classes. And you would go to a qualified school where they offer these kind of family violence training classes.
And is this like every day or once a week? Or?
Once a week, weekly. Weekly is once a week.
Gotcha.
and they're very affordable and they, work around your schedule. It is once a week and it's a consecutive 24-week class. And it's about an hour a week.
Okay.
Is that something you'd like to consider?
It is something I consider.
Okay.
The only
Uh,
other, Judge, I would
yes.
ask, and this is something that Ms. Marshall Story and I also discussed. So I'm not trying to trespass on the case, but I want to make sure he's making himself clear. Judge, he has no record. I did explain.
Your Honor, is Ms. Rockwell entering her appearance? Otherwise, I'm just not sure the relevance.
Yeah.
I can email you an entry. I just didn't want, sometimes judges are very concerned about lawyers entering late. The only thing I wanted to tell Your Honor is that he was requesting first offender treatment. That's the only thing, because he has no record.
Understood. Okay, I will consider that. Ms. Marshall Story, are you able to present the plea paperwork today with someone from your office?
Your Honor, yeah, I mean, I can fill it out and just forward it to.
And if you could, Ms. McCutcheon, once you've got the plea paperwork drafted, could you please CC Ms. Renee Rockwell? And please send it to Ms. Younger as well, so she can print it
Your Honor, again, the objection is still the same. If Ms. Rockwell is on the case. then
She's not on the case.
Okay, then
She's
why,
not on the case.
why would we be seeing her on?
A judge, and listen, everybody, just to make this clear and quick, if the court allows me to file my entry, I will send it, email it to you.
Okay.
I think it would make it a lot cleaner and quicker.
All right,
He-
what we're gonna do, Miss Rockwell, is we're gonna put the Miss Younger's email in the chat. And before, when I'm ready to take Mr. Eddie's plea, I would need to see Miss Smith, excuse me. You need to send it to Miss Essen Smith, email, and she's gonna put it in the chat to you. And, please email your entry of appearance to, Miss Smith, and we'll have it filed so that you're filing as entry of appearance for purposes of addressing the plea in State versus Eddie.
Thank you, Judge.
All
And
right.
I don't, the state has an objection to me jumping in at this point, then, correct? All right. Okay, Judge, I'm gonna stand down. I will email that. And may he be excused just to go into the hallway because they asked him to turn his phone off so I can go over his rights with him, Judge.
Certainly, all right.
Thank
Mr. Eddie, if you'll step in the hallway, Ms. Rockwell is going to call you on the phone, and she's going to go over everything that we just discussed. All right, so position number one, State versus Charlie Eddie is entering into, that's going to be a plea hearing.
And Your Honor, respectfully, the victim is present. I don't know if she would like to make a statement, but I do want to give her that opportunity.
And she will have that opportunity at the plea hearing, okay, which will be very shortly. Do we have any other witness who was brought in for this case?
Yes, Your Honor. The sergeant that was involved in the matter, Sergeant Smith, is present. I would like all parties to stay though until this plea has been completely tendered. If you don't mind, Sergeant.
Sergeant Smith, the court is allowing you to leave. Mr. Eddie is already committed to a plea, but if you want to stay and Ms. Marshall's story requires you to stay, that's entirely up to you. Okay, thank you. All right, then we move on to Maurice Robertson. Mr. Robertson, you need to come up to the podium.
And Your Honor, the state will be objecting to a bench trial, and we do have argument.
Hang on, let me get your phraseology correct. You are objecting to a bench trial, so you want a jury trial as well?
Yes,
Oh, so you are in concurrence with Mr. Robertson.
correct.
All right, so if you both want a jury trial, then there's nothing else for me to address. I thought y'all had set this down for a bench trial, called your officers.
No, Your Honor, this was set in, I apologize, Your Honor, but this was set on the bench trial calendar in order for the defendant to retain counsel. From our records, the last time he was before Your Honor, he didn't have an attorney. So he was reset because he was already reset twice in the status calendar. So he was reset to the bench trial calendar for the purposes of retaining counsel.
Okay, so it appears that he has, Mr. Stein.
No, he told me to say, that was wrong. He was been consulting me. So now jury trial for me to go ahead and get
Where's
that.
your attorney?
That's what I just got on the phone with him. He said it was like leading. He said he'd been consulting me. I would meet with him, so he would be my lawyer.
Where is your attorney?
He's not here, ma'am. That's why I
He's
called.
supposed to be here.
Oh. Technically, that's why he said it was misleading the court because that's why he told me to come back in here and say that. Because he's been consulting me. He said, now go ahead and pay him and he will. That's what he just told
I
me.
need him here now.
He won't be here now.
You were told to bring an attorney today.
Well,
No, listen very carefully.
ma'am,
I can find you in contempt.
I don't want to be in contempt.
Well, you are very close to it.
When I spoke with him, he said, just go tell them. This is what he told me.
Tell your attorney,
But he,
I'm very close to finding you in contempt for failure to produce an attorney today when you were required to do so.
well, ma'am, he told me the Oracle case is no, I can call him, ma'am. I mean, I
Mr.
don't want to,
Robinson, let's get some ground rules down. You're the defendant, you have an attorney, and I'm the judge. This case was reset for you to come to court with an attorney. With an attorney. You are standing here, no attorney. which means you have violated the court's ruling.
I didn't mean to do that. I was
I
just
don't care whether you mean to do it or not.
going on what he told me. to
I
say.
don't care what he told you. The judge, whether it was me or the other judge, told you to show up in court with an attorney. I want that attorney in the courtroom.
Can I go call and
Exactly.
call again?
Thank you. We'll be in recess until Mr. Stein appears.
Your Honor, if I may, Denise Riley for the state. If I could give some of the procedural history regarding. Mr.
I
Robertson's
really
case.
don't need it until Mr. Stein appears, because that's his attorney.
Well, Your Honor, I will say on May 4th of 2021, in front of Judge Richardson, Mr. Robertson pled not guilty and requested a jury trial. That is on file in case manager
Okay,
under documents.
all right. I still need the attorney here. All right, so we're going to be recessed until Mr. Eddie's ready with his plea. And then we're going to take up the issue of contempt in State v. Robertson. Thank you. Good afternoon. There's a Christine Hacker on the Zoom. Ms. Hacker, this is a bench trial calendar. You're not listed on the calendar. What are you here for? Ms. Christine Hacker, can you hear me? Was she on this morning's calendar, arrangement calendar?
I have the comments from the other.
Is the plea paperwork with Mr. Eddy?
The state just printed it out.
Okay. Ms. Christine Hacker, if you can hear me, please unmute your screen.
There we go.
Okay.
Yes.
My name is Judge Lal, and this is a bench trial calendar for 1:30 p.m. today.
Mhm.
Your name is not listed on the calendar. Are you a interested party in one of the cases?
My hearing was for 9 this morning, and I have had some technical difficulties trying to log in, and I was finally able to log in.
Nine o'clock. Yeah, that calendar is long gone.
I'm surprised it let me come into this one. I thought I just clicked the link for mine.
I'm surprised you didn't come down to the courthouse.
No, I did the call at work. I was
You
at
can't,
work.
if you can't appear via Zoom, you're required to come down in person.
Well, I didn't know it wasn't going to work until
Well,
I
let's
was.
see what was ruled. What's your case? Hang on. Was this the arraignment calendar, right? Okay. No, I just had.
The next one. What is the name of the defendant on Zoom?
Okay, here we go. Hacker. Yes. I don't have a hacker on this calendar.
That name does not sound familiar.
What's your case number?
Hold on, let me pull up the email. One second. I'm sorry, I'm trying to find where the case number would be in the email. Okay, it is 20 CR 001279E.
You were supposed to show up in court yesterday at 9 a.m. So most likely a bench warrant has been issued for your arrest for failure to appear. If you want to resolve the bench warrant, you need to retain an attorney and file the appropriate motion to set aside the warrant. Otherwise, you can turn yourself in at the Fulton County Jail. I'm going to check and see what I ruled on in your 12:15 at 9 a.m. Was she on the status calendar?
Yes.
Okay. Yes, Ms. Hacker, a bench warrant has been issued, $1,000 surety bond. Not only did you get the wrong date, you got the wrong time. All right, you're on mute, so please remember to contact the public defender's office if you see you qualify for their services, or you can surrender yourself to the jail. The bond is set at $1,000. Thank you. Is Mr. Eddie ready?
Yes, out in the hallway talking with Ms. Rockwell, I do believe.
All
I've
right,
given
who
you-
spoke to Mr. Stein or Mr. Ramos? Was that you, Mr. Tortorella? Who's the attorney? Yeah, what,
I spoke to him, Your
Mr.
Honor.
Robertson, you can, let's resume with State v. Maurice Robertson. Case number 20 CR 002-847F. Yes, let me just get some procedural issues down first. This case was scheduled before Judge Eric Richardson. Pursuant to time, these cases were then transferred to the Orca program to be set for a bench trial. Right? So now it appears that Mr. Robertson wants a jury trial, and the state is also open to the concept of a jury trial. So this case is going to be reset for the Orca jury trial calendar. And y'all will get notice of when to show up to court, when to be ready, so forth and so on. Now, the other issue I have to address is whether to find Mr. Robertson in contempt for failure to present an attorney when he was specifically instructed to do so in court. All right, now, did you have something to add with pursuant to your conversation with, I don't know who you're talking to?
So I was talking to the attorney, Your Honor. But before, I would like to ask this honorable court if your notes match the state's. We had notes that stated that this case was reset from the status calendar so that he could retain counsel.
Yes.
Okay. So I spoke to the attorney. He said at this time he does not represent him, that his wallet was stolen. And he's just
Stolen.
waiting,
The attorneys?
the defendants,
Okay.
and that he's just waiting to be retained, that at this time he is not his attorney.
Okay. Mr. Robertson? That is not your attorney.
Right, he's been consulting me, and I have case numbers for him. I have all this and stuff. I'm supposed to pay him for him to actually represent me. That's what he explained.
Your Honor, I have his number if.
No.
So that's what it was. So I was like, can I use you? He's like, yes, just tell him this, boom, boom. And he was like, the non-Orca style calendar represent, they don't know what to do. So he's like, just tell him you need a jury trial to have more time. So I did ask him, whom he know I'm going to let him represent me. So
Your attorney said, just come on in, ask for a jury trial, and I'll just automatically continue the case.
well, he said I should have time for a jury trial.
Mm.
That's what he told me. That's why I kept trying to explain to you. That's why every time I went to the
Which is
hall.
fine. I'm going to put it on a jury trial. My question now is you are supposed to show up in court with an attorney.
But when I asked him that, I kept, every time I read him, this, he has copies of this. I would screenshot it and say, he was like, well, you could show and just ask for, that's just what he was telling me. And
I don't care
I understand that.
what you got was
I don't wanna-
incorrect advice
I'm sorry.
because you were expressly told to show up in court with an attorney.
And I apologize.
That's what you were told. And you did not.
Apologize. Man.
I'm going to have to find you in contempt.
There's no way that can be waived. I didn't mean to disobey you. I was just calling the attorney to find out how to,
When did you pay your attorney?
I'm going to pay him. He was just consulting me that. I asked him, could he represent, he told me, I was calling him. He was told me how much he wanted. He said, well, these style cases here, they just don't know what to do yet. He said, so go down, it's been passed down from judge to judge to judge to judge.
No, it's not.
The majority of them was Zoom calls. Majority of them was Zoom. I went through 4 different ones that's on Zoom.
What difference does it make? How many judges are in your case?
Because they didn't, because they didn't know. Every time it would just be like, oh, and I'll say this, they'll be like, oh, okay, then I, yeah, show these. So that's when I started getting them, and that's when I called Mr. Stone. He was like, well, let me see what's going on here. He'll look, he said, well, you can go. He said, all the rest of them, you was doing Zoom. He said, well, this last one, when I first met, like, appeared in person. So that's when my name wasn't even on the calendar. So then it was reset this time, and that was
What's the name of this attorney?
Raymond A. Stein. Raymond A. Stein.
Raymond Stein? Is that who you're talking to? Ray Stein?
Yes, Your Honor.
Okay. Today is December 16, 2022. Now I want to make sure that I don't misquote any of this information in here. You were arrested for DUI this February 11th, 2019. 2019. You were in jail. You were represented by PD. I don't know what happened after that. Since then, there's not been a single entry of any attorney in this case. But just from this year alone, this case was reset May 20th, 2022 by defense. Was reset June 17, from June 17, 2022 by defense. On July 29, 2022, it was reset by the state. Then it came back on the calendar on October 28, 2022. And this time it was reset to December 16, 2022 for you to show up with an attorney.
Understand?
Oh, no, I've already heard your side. This case has been going on for some time. Judge Richardson, who originally had the case, had transferred it to the Orca calendar so that we can start to address these cases and they don't languish for a long time. I find that you spoke to your attorney at the 11th hour, very late, and that you failed to pay your attorney in a timely manner so that he would appear in court. Are you telling me, Mr. Robertson, that Mr. Stein is not in the courtroom, even though you've not paid him?
Yes, because
He was supposed to show up in court.
no. He was never. He was aware of every court date, and I would talk to him frequently. Like, what should I tell him? He was like, well, these type style cases, like you said, they don't really know what to do. So just ask for a jury trial, then come see me. But I was like, can I use you as my attorney? He was like, yeah, because I'm going to pay him. He know I'm going to pay him. So, and that's why when you said attorney, you go out. He said, no, don't mislead the court. That's why I came back and said he was consulting. Not that he's my attorney. I am going to retain him now. Now, yes, I will retain him now. But that's why he was telling me, no, don't mislead the court.
Mr. Robertson, you failed to show up in court with an attorney. I'm going to fine you $500. I'm fining you in contempt of court for failure to comply with the court's order. The fine is $500 or 1 day in jail.
When would I have to pay the $500?
By your next court date.
Oh, that's fine.
Your next court date is going to be, do we have January 27,
That's fine.
2023?
Thank you. Would I get a notice with the fine also?
You will get notice just like you got notice to show up today.
Okay.
Oh, I'm so sorry. It can't be January 27. Oh, well, we have a final plea calendar, right? Okay. It's going to be scheduled for a final plea.
Final plea.
Yep. Your attorney can speak to the prosecution and see if y'all want to consider a plea offer.
Okay.
Otherwise, we put it on a jury trial calendar.
I'm going to definitely have him. I'm not worried about it. Is there any way this non-contempt, is there any way this fine can go away? Ma'am, I was going on with my lawyer. Well,
Listen very carefully. All you need to do is make sure your lawyer is in the courtroom with you.
Okay.
In person.
All right.
On January 27th at 9 a.m. OMG 33. Your fine of $500 must be paid to the court registry or to the court treasury before January 27th.
Oh.
not on January 27th.
before.
The deadline is January 26th.
Well, and I'm gonna get that notice in the mail. I just want to,
Answer the question. I'm not answering it again.
I don't get everything in the mail. If some stuff don't show, some of these don't show sometimes. Yeah, okay, yeah.
And Your Honor, I'm sorry, go ahead.
And if your attorney files an entry of appearance, your attorney will get notice of the hearing as well.
Okay.
That's up to the both of you. Yes, ma'am.
Your Honor, I just want to make the court aware that the defendant never filed any such waiver of his rights for a jury trial.
That's why I started with the preamble, that the case was originally scheduled with Judge Richardson. Judge Richardson assigned all these cases to the Orca program for the bench trial program. So if there was a mistake, I'm not finding him in contempt for demanding a jury trial. I'm finding him in contempt for the very specific reason of failure to bring his attorney to court as previously instructed.
I understand, Your Honor, the state does understand that. However, I'm not sure if in the future, when these cases are scheduled for a bench trial, they can be double checked that these defendants have actually waived their right to a jury trial, because there had been something filed for him about a waiver, but he did not sign anything. He did not waive. So if the court can please take notice of that.
I will. We have to double check all these cases scheduled for bench trials now. Okay. Anything else, Mr. Robertson? All right, thank you. You're free to go.
Mr. Robinson, did you fill out the form?
All right. We are addressing Mr. Eddie. Is he ready? Mr. Trejo, did you have a case with us?
Yeah, I tried to contact Mr. Raffoff regarding the position with Mr. Adams yesterday.
Yeah.
And we could not get Mr. Raffoff, so Mr. Trejo is stepping in on his stead.
Okay, let me just,
That was the Orca final plea.
was that 794E?
Are you referring to the case number, Your Honor?
Yeah.
That's right. 794E is the number that I have as well.
Okay. All right, we are addressing State versus Demetrius Adams, 20 CR 0000794E. This case was on the final plea calendar on December 15th, 9 a.m. On the Orca program. Mr. Adams appeared in court represented by the Public Defense Office through attorney Michael Rapoport. And on record, Mr. Adams agreed to pay the victim $1,000 cash by delivering the funds by 3 p.m. on Eastern Standard Time on December 15, 2022. So, Ms. Wiley, what's your announcement?
Your Honor, we have received contact from Mr. Larry Spamberger, who is the manager at the title loan company. He has not received the $1,000 payment to clear the loan, nor has he received the collateral, which was a 2014 Nissan Maxima. Therefore, the state would state that Mr. Adams is in violation of the court's direct order to have that paid by 3 p.m. yesterday, Standard Eastern Time.
All right. And Mr. Trejo, I believe Mr. Adams was cautioned numerously by me or numerous times that failure to pay will result in a bench warrant or a order of contempt, because in exchange for his failure, the state had decided to null cross the case. That's what we have. Anything to add, sir?
Nothing additional, Your Honor. I remember that client being called yesterday. I remember part of the conversation with him. I had stepped out of court by the time. I know that the court had some representatives from the title company on Zoom. I was out of the courtroom at that time. I was speaking to some other clients. But to date, Your Honor, if if that's the extent of the information that the court has, without having spoken to Mr. Raffoff or without having spoken to the client directly, at this moment I don't have anything additional to add. I really don't have any other additional information on the situation. I have notified the other members of our Orca team, see if they've spoken to Mr. Raffoff today. I have not seen him around the office today. I know he might have had court this morning, but that's the extent of my knowledge.
Okay, I have a show cause date. It's going to be, don't we have a show cause date from yesterday, Ms. James? Was it January 5th?
Say again?
The show cause date.
Yes, Ron. Yes, Ron. Yes, sure.
I just want to confirm the date.
Yes, Your Honor, January 5th, show call.
January 5th. And we're going to put him on the status calendar, this case. Mr. Adams. Mr. Adams has until that court date. It's going to be a show cause calendar for him to pay the fine, the $1,000 to Mr. Larry
Spamberger, Your Honor, if I could quickly perfect the record, it is $1,035 to clear the loan.
I think he agreed to a lump sum of $1,000.
Yes, Your Honor.
Okay, it was $1,000 to Mr. Larry Spamberger of Title Loan Company in Fairburn, Georgia. Otherwise, a warrant will be issued for his arrest at the show cause.
Understood. Excellent. And I'll continue trying Mr. Raffoff, and I'll see if I can reach the client myself. But at either, regardless of who we're able to reach first, Your Honor, I'll make sure that they have they'll have that message loud and clear.
Thank you, Mr. Trejo, for chiming in on this one. Thank you.
Of course. Thank you, Your Honor. And may I be excused, or would you all prefer that I stay on for a bit?
No, you definitely may be excused. I was told that your namesake was on our calendar and everybody stood up to assure me there was no relation.
No relation.
Okay, take care.
No relation.
Bye.
Thank you, ma'am. Have a great day.
Oh, all right. Are we ready to address the plea for Mr. Eddy?
Yes, Judge. I just have to find out from Madam Prosecutor exactly what charges he's going to be pleading to. The second thing,
It's going to be battery, domestic violence, first offense.
Battery, family violence, Your Honor.
Okay. And the remainder charges of cruelty to children, third degree. Yeah.
Are we able to see,
You know,
Rockwell? Can we turn the Zoom back on?
I have no ability to do that. That is set by the court administrator. Do you want to wait and get them to do it?
Well, have you received the?
Okay, you can Zoom, you can chime in on your laptop, someone, or your phone, and you'll be able to see Ms. Rockwell.
Okay, have you received the entry of appearance?
I am, Mr. Rockwell, did you send the entry of appearance?
Judge, I sent it to Essence Smith and to Erica Marshall Story. And let me apologize, Google Fiber is out in my building of all days for it to be out. So I had to scribble. You'll see my D penmanship.
What else could happen today, right?
I have received it, Your Honor. Has the court received it?
Excuse me,
I did not
Judge.
send it to the court. I sent it to Essence Smith and,
Yeah. We have it. We have it.
okay, and Miss Marshall Story.
Okay.
Excuse me, Judge Lael.
Yes.
I apologize for interrupting. I just can't see the ASG. So is Miss Marshall?
I'm going to ask Miss Marshall to wave a hand. Can you see the person?
barely.
Yes,
It's very tiny, sorry, so I can barely
that's
see it.
okay.
I also cannot hear her very well. I don't know if she moved away from the microphone.
You're a little distant from the mic. That's right there. So if you, Miss Riley, could switch spots, that would help. And then
Thank you very much.
you'll be able to hear her, but you might not be able to see her anymore. It's the quandary of the logistics in this courtroom. Okay. All right. Ms. Smith, she's filed, you've got the entry of appearance. Okay, Ms. Renee Rockwell has submitted a handwritten entry of appearance for Charlie Limpty Eddy case number 20CR 003-435F. This case was scheduled for a bench trial, but now it appears that Mr. Eddie has been represented by attorney Renee Rockwell, and we're going to proceed with a plea hearing instead. Mr. Eddie, if you'd like to come forward and take the podium, please. No problem. And Ms. Smith, you have the plea paperwork, or you can forward it to me.
Did I get the signed paperwork?
I believe that Mr. Eddie still has it.
Mr. Eddie, is those the documents?
Yes, ma'am.
Have you reviewed it with Ms. Rockwell?
Yes, ma'am.
May I see the copy, please?
And Judge, I give the court permission to sign my name on the verification page and also to sign my name on the plea.
Okay.
I'm sorry for interrupting again.
Go ahead, go ahead.
I put some information in the chat. I sent a chat to Miss Rockwell.
Mhm.
And if you could answer it, I put my email in there. I just need your contact information. And if anyone has a copy of the calendar, it would be helpful. And also if I forgot
ahead.
the other thing. I'm sorry. I
Ms.
got called
Marshall,
15 minutes before to get on this call, so I just don't have very much information.
no problem.
I don't know if you need me for any other case after this plea, but just let me know. That was it.
No, this is the only case left.
Okay.
Okay. And Ms. Marshall Story, he's pleading guilty to battery, family violence, or
That is correct, Your Honor.
okay,
That is,
it's got cruelty in the 3rd degree. Do I stretch that out?
is that actually on the plea paperwork?
Yes, it is.
Yes, Your Honor.
Okay.
Please.
Thank you, Ms. Marshall Story.
Yes, Attorney Rockwell.
And Ms. Court Reporter, that's Courtney, right?
Yes.
Because I signed out, I didn't see any text message to me, but I just put my name and my email address. And I'll also put my phone number in the chat.
Okay, so you don't see my email and my information to you? All right, I'll get it out of the chat. That's fine. Thank you.
Okay, I've got the written paperwork. Thank you, sir. Appreciate it. Ooh, no, that's okay. I got another pen. I got another. Thank you. Oh, long arms. Okay, thank you. All right. We are going to resume with this plea hearing for State versus Eddie. And Mr. Eddie, you have a right to remain silent about the facts of the case. Anything you say, your statements can and will be used against you. You have a right to an attorney, and Ms. Rockwell has filed an entry of appearance and is representing you for purposes of this plea. Do you understand, sir?
Yes, ma'am.
Okay. Since this is a negotiated arrangement, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. All right, Ms. Marshall Story with the Solicitor General's office. What is the plea offer, please?
Your Honor, the defendant is pleading guilty to the charge of battery, family violence, first offense. That is a misdemeanor charge, Your Honor. The state is recommending the following as part of his plea to that charge. 12 months to serve 72 hours with credit for time served. The defendant should also complete the domestic violence intervention program. We're asking that the balance be probated and that there be no early release from probation, no early termination of probation. We're also requesting, Your Honor, no further violent contact with the victim, who is Marshetta Brown. And I would like to point out that Ms. Brown is in court as well. In court with Sergeant Smith of the Fairburn Police Department, and both were prepared to proceed to trial.
Thank you. I believe Ms. Brown wanted to say something. If you'd like her to do it from your table, that would be better. for the
Your
record.
Honor, I have consulted with her and she has opted not to make a statement at this time.
All right, thank you. Ms. Rockwell, you've spoken with your client, I believe, in the hallway prior to this hearing. Does he,
That-
in terms of this offer?
Yes, that's correct, Judge. And I do want to tell the court and Madam Prosecutor that we did scratch out on the plea sheet because it had NC, no contact, so we put NFVC.
And Your Honor, I have spoken with the victim regarding that and she is perfectly fine with no further violent contact because they do share a child together.
Okay, thank
Understood? That is noted for the disposition.
you, Judge.
All right. And stipulate to the factual basis, venue and ID for the charge of battery family violence.
So stipulated, Judge.
Thank you. Mr. Eddie, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And are you doing so freely, willingly, and voluntarily?
Yes, ma'am.
And you've already spoken to Ms. Rockwell. Has it been explained to you that if you decide to take this plea offer, you would have to give up your constitutional right to a trial, to give up your right to go back to court, confront your accuser, examine witnesses, have the assistance of an attorney so that you could challenge the state's evidence or be able to argue your defenses, if any, to the jury?
Yes, ma'am.
And you're giving up your right to have the state try to prove the original charges against you beyond a reasonable doubt. Are you doing so?
Yes, ma'am.
How do you plead to one count of battery domestic violence?
Guilty.
Your sentence is going to be 12 months, serve 3 days, credit for time served 3 days. You don't have any further jail time, you will be placed on probation. You must report to probation next week, Thursday, December 23rd, before 3 p.m. At that time, your probation case will be open, and then you would need to comply the conditions of your probation, which is commencing a 6-month domestic violence program called DBIP or FVIP. You will pay for those classes out of your own pocket. At all times while you're on probation, you're not to have any violent contact with Ms. Marshetta Brown, which means no physical altercation, no verbal altercations. If anything results in a subsequent arrest, you risk the chance of your probation being revoked and completing the rest of the sentence in prison. Do you understand, sir?
Yes, ma'am.
I will suspend your probation fees up to and including the end of June 2023. After that, you will continue to report to probation and start paying probation fees from July 1st, 2023 onwards. Do you have any questions about your
And how long is this probation fees or?
probation fees are about $50 a month.
How long?
It will commence this month and it will end on December 17th or 18th, 2023.
Okay.
Anything else?
I guess it's just getting the understanding that I hear as far as the first offenders part.
I was about to address the court, Mr. Eddie.
Okay, go ahead.
Yes, ma'am.
Just for the record, he is 42 years of age. This did happen in May of 2020, as I understand. For the record, I have reviewed all the evidence, the police report, and the videos. I want the court to know that he was born in Amory, Mississippi. That is spelled A-M-O-R-Y. He attended high school in Mississippi, graduated in 1998, and then attended college where he studied criminal justice. He is not married. He does have 4 children, 19, 15, 2, and 1. My understanding is that he's had an amicable relationship with Ms. Marshetta Brown, that he does support the child. He is gainfully employed, Judge. He is in the finance department at Auto Nation. And he is not on probation, parole, any type of suspended sentence, nor does he have an open case right now. It was very important to him, Judge, that I explained the workings of first offender. It was very important to him to request first offender treatment to from the court. I've explained to him if he successfully completes this probation, he can essentially be without a record and would be discharged without having a conviction for this particular offense. I think he's a good candidate for a probation judge. I would ask the court to consider first offender treatment, although I hate to use first offender treatment on misdemeanors because usually I try to talk folks out of it and reserve them for a felony. But I'm satisfied that at his age, that you won't see him getting into any trouble. So I would ask you to allow him to use first offender. Finally, Judge, under 42-8-62.1, I would ask the court to allow this matter to be sealed on the front end. I think that the request that I need to make with the court is that his right to privacy in this matter outweighs the public's interest in what happened today in court. So therefore, I'd ask the court to consider a seal under 42-8-62.1. When my Google Fiber comes back up, I will, if the court so grants that, I will submit an order to Madam Prosecutor and Your Honor, if the court grants that seal under inner statute.
Thank you. Ms. Marshall-Story, you have two issues to address, the first offender and the request to seal.
Your Honor, the state understands that it is within the court's discretion to allow first offender treatment. We would object to that, Your Honor, based on the nature of the charges. There were substantial bruising that was involved. The defendant, not sure if the court is aware, but I'd like to point out a few facts in the case that would have come out at trial. The defendant dragged the victim out of bed, causing bruising to her elbow. I do have pictures of that bruising. The defendant was intoxicated at the time and decided that it was in an infant's, when I say infant, I mean 4 months old at least, or at the minimum. In that infant's interest to be brought outside in May at 4 o'clock in the morning to perform a prayer ceremony. That is obviously what led to the victim in this case being very, very upset with the defendant that he would endanger the child in that manner. And for those reasons, Your Honor, we do believe that a first offender treatment is not warranted in this particular matter based on the facts. And additionally, the defendant would be subject to increased penalties. And we're asking that you not seal the matter. Should be a matter for public record that he has committed this particular crime and has pled guilty to it.
All right. I have read the warrant. It doesn't go quite as much detail with regard to what Ms. Marshall-Story has indicated. But I also weighing that in comparison to Mr. Eddie's limited prior history, his current employment status, the fact that he's had amicable relations with the alleged victim. He's engaging in amicable co-parenting with the children he shares with the victim. I'm going to grant the first offender treatment with proviso that I'm adding a provision of no alcohol and no illegal drugs while you're on probation. Do you understand what that means?
I do believe so, but see, I guess no use of alcohol or drugs. Take it.
You cannot consume any alcoholic beverages and no illegal drugs while you're on probation, and you'll be subject to random screens by your probation officer. If you fail if a drug test or if you fail an alcohol test, they have the right to have your probation revoked.
Okay.
Do you understand, sir?
Yeah.
Are you willing to comply with that?
Yes, ma'am. One question though.
Yeah.
I did hear you say for the first offender. But is this also in terms of the making it public? I want to make sure I word it.
I'm going to address the request to seal in a moment. But I just want to make sure that you understand, I'm granting you first offender treatment, which means that in any subsequent proceedings, they cannot bring this conviction against you. But
Yes,
if you violate probation, then the first offender protection is off.
yes, ma'am.
All right. So no alcohols and no drugs.
Yes, ma'am, certainly.
And also, since you are being convicted of battery, domestic violence, you're prohibited from possessing or owning a firearm. Do you understand that?
Is that while on probation or forever?
Well, while you're on probation. And as long as you complete all the requirements of first offender.
Okay.
Do you own any weapons or firearms?
I don't own any, but I hunt sometimes. No, ma'am, I don't own any.
Well, not while you're on probation.
Well, I can't hunt even if I don't own a weapon, but
I don't know. I don't engage in hunting, so I have really no idea. Sorry.
Well, she means you can't possess a firearm while you're on probation.
I understand. Thank you.
So you can't hunt unless you go bow hunting.
You mean fishing?
Or
Is that what you meant, Ms. Brockman?
no, bow hunting, meaning like if he wants to go hunting with a bow and an arrow, he could.
Oh, bow. Okay, got it.
I do want to say this, Mr. Eddie, the judge has changed the recommendation a bit. Do you understand that? And you're still asking the court to accept your plea, correct?
Yes, ma'am.
Also, do you object with me appearing via Zoom while you're in the courtroom? Do you object to that?
No, ma'am.
All right. With request to the requirement that the conviction be sealed, I'm going to deny the request. I do not have sufficient showing of the extraordinary circumstances that required this conviction to be sealed. We have hundreds, if not thousands, of convictions that are public record in order to make sure that this information is available to the public. This is a public proceeding. This is a public case. There is no extraordinary circumstances that require the matter to be sealed. So I'm denying the request.
Thank you, Judge. May at the end of the probation, may I address that issue?
You may definitely do so. And by the way, also under the specific statute that Ms. Rockwell's articulated, she can always bring that up with the prosecution at the conclusion of your probation. If everything goes smoothly, I have seen situations where the prosecutions have agreed to seal it after successful completion of probation. Do you understand what I mean, sir?
Yes, ma'am.
All right. Okay, that concludes the case. Thank you very much, Ms. Rockwell. Appreciate you stepping in. Mr. Eddie, if you'll please have a seat. You'll need to fill out some information for probation. And he'll report to probation next Thursday, December 23rd before 3 p.m. at 132 Mitchell Street, downtown Atlanta.
What's the suite number, Judge?
Oh, God, I don't know. It's just a building. And you can tell by the traffic.
Okay.
Yeah, it is.
I'll help him get there. Thank you. May I be excused? And you have my permission, Judge, to sign my name on both the plea, the right sheet and the plea itself.
Thank you. Appreciate it. Okay.
Thank
Ms. Howard,
Thank you, Ms.
court, thank you, Ms. Rockwell. Ms. Howard, court is concluded as well. We're done. Thank you.
Thank you very much, Judge
All right.
Hall.
Thank you. Everyone be safe. Happy holidays.